Welcome to This Explainer. Today, we're diving deep into exactly how Indian law is rapidly catching up to emerging technology. We're going to look at a clear blueprint of the sweeping, active changes that are fundamentally altering the legal landscape right now, in 2026. Whether you're a content creator, a tech builder, or just a digital citizen, these are the guardrails defining your online reality. So if you want to understand exactly how the rules are being written around artificial intelligence, deepfakes, and connected devices, you are absolutely in the right place.
Here's our roadmap for today. We'll start with the AI regulatory landscape, then break down the new rules on synthetically generated information, and cover the strict new compliance obligations. After that, we'll look at legal tensions and critiques, explore the personality rights track, and finally wrap up with IoT and blockchain liability.
All right, let's jump right into Section 1, the AI regulatory landscape, and establish our baseline.
India's macro approach to AI is actually a really fascinating tale of two completely different tracks. On the regulatory front, there is literally no standalone AI law. Instead of passing a bespoke, dedicated statute, the government is shoehorning tech regulation into the existing information technology rules framework. Prior advisories from 2023 and 2024 asking platforms to label AI content, those actually had no binding legal force. Now contrast that with the government's aggressive industrial policy track. They are heavily pushing capacity through the India AI mission, which focuses on compute infrastructure, and the newly established India AI Safety Institute. But remember, building compute capacity is industrial policy. It's not a regulatory statute.
Let's move on to Section 2, synthetically generated information, which is easily the most significant legal development of 2026.
This was directly triggered by a crisis of viral deepfakes targeting politicians and celebrities, and the timeline here is just staggering. Because courts were flagging the lack of a statutory hook to fight AI-generated harm, the government moved incredibly fast. On February 10, 2026, MeitY notified the IT Rules Amendment. To go from a notification on the 10th to strict binding enforcement just 10 days later on February 20th, that is practically unheard of for massive tech conglomerates. It proves exactly how urgently the state viewed this issue, even as this lightning-fast rollout sparked some serious industry criticism.
So, the absolute core of this new law is synthetically generated information, or SGI. Put simply, this is AI content trying to pass as real. It covers any audio, visual, or audiovisual content algorithmically created or altered to appear reasonably authentic or indistinguishable from a real person or event. But here's a crucial detail. The law protects everyday internet culture. It deliberately excludes routine edits. So don't worry, nobody is going to jail for using a puppy dog filter or fixing the lighting on an Instagram post. The real target here is weaponized deception, not everyday fun.
Okay, Section 3, strict new compliance obligations. Let's look at how this definition impacts the platforms we use every single day.
Platforms are now forced to navigate a total maze of new mandates. First up, qualitative labeling. An early draft in October 2025 actually proposed a rigid rule where watermarks had to cover 10% of an image. Well, they dropped that. Now SGI must be clearly and prominently labeled, meaning it's assessed by whether an ordinary viewer actually notices it. Next, where technically feasible, platforms have to embed permanent provenance metadata trace content back to its origin, and users can't be allowed to strip that away. We're also seeing heightened proactive detection rules for significant social media intermediaries. Those are the big ones with over 5 million users. And perhaps most radically, MeitY now has direct executive blocking powers. They can force a platform to take down content immediately without even waiting for a public user complaint first. That is a massive shift in digital power.
And think about how fast the internet moves. Under the old 2021 IT rules, platforms had a 36-hour window to take down flagged unlawful content. Well, that timeline has been radically slashed. Most reporting now converges on a strict 3-hour takedown window for removing flagged unlawful SGI. And for the most severe categories, things like non-consensual intimate imagery and deepfake nudity, reports indicate it's down to just 2 hours. Guys, that's less time than it takes to watch a single Bollywood movie for platforms to detect, review, and scrub viral content globally.
This brings us to the real enforcement teeth of this entire amendment. If a platform misses these lightning-fast deadlines or fails to properly label SGI, the consequence is the total loss of their Section 79 safe harbor protection. This means a simple content moderation failure instantly converts into a direct liability trigger. The platform is stripped of its immunity and can be sued exactly as if they had created the unlawful deepfake themselves. Huge stakes.
With such high-stakes rules rolling out, we hit Section 4, legal tensions and critiques.
Is this new framework flawless? Well, the short answer is no, and it is highly contested. Let's impartially map out the very real critiques these rules have received, because this is a genuinely live, unresolved tension that will almost certainly end up facing severe judicial challenges in court.
We have to look at both sides of the scale here. The government's goal is to swiftly combat harmful deepfakes to protect citizens and elections. But groups like the Internet Freedom Foundation, or IFF, argue the approach is deeply flawed. They point out that judging if something looks authentic to a reasonable person is a dangerously subjective standard. Unlike the EU AI Act's risk-tiered model, India's broad stroke could sweep up low-risk, everyday AI uses, like basic translation tools. On top of that, mandating warnings on content could act as compelled speech, raising concerns under Article 19(1)A, India's constitutional guarantee of free speech. And to make matters worse, platforms are being forced to use AI detection tools that we factually know are often highly unreliable.
Before we leave the IT rules entirely, here's a quick heads up on something still evolving. In March 2026, MeTi released the draft IT's Second Amendment rules. This proposal would extend digital media ethics code obligations to individual social media users who post news or current affairs. It effectively proposes pulling ordinary citizens into a regulatory framework that used to be reserved for actual news publishers. Now, it's absolutely critical not to conflate this with the deepfake rules. The SGI framework we just talked about is live, binding law right now. This Second Amendment is still just a draft in public consultation.
All right, let's step away from top-down government regulation and look at Section 5, the Personality Rights Track. So we essentially have a two-track system operating in reality. Track 1 is the heavy regulatory hammer falling on tech platforms globally through the SGI compliance rules. But Track 2 is highly personal and civil. High-profile figures, like Bollywood actors, are going directly to the Delhi High Court to protect their personality rights. They are securing interim civil injunctions, suing specific individuals to stop their faces, names, and voices from being hijacked by AI for profit. Getting a well-rounded view of deepfake law in India means you have to understand both of these active tracks. Finally, let's pivot to Section 6, IoT and blockchain liability, looking at two massive verticals where the legal landscape is still incredibly underdeveloped. Because there are no dedicated statutes for the Internet of Things or blockchain yet, courts essentially have to rely on legal duct tape, general fallback laws. If a connected smart device causes harm, courts look to Sections 82 to 87 of the Consumer Protection Act for manufacturing defects, basic tort principles of negligence, or the new DPDP Act if your privacy is breached. For blockchain, verifying a smart contract relies on Section 10A of the General IT Act. And for blockchain patentability, courts rely on the specific Priya-Randolph case, which extended the technical effect test to blockchain inventions.
The big takeaway here is that there's a bit of an illusion of safety. You might hear all about government IoT security certifications from BIS and STQC, or a national strategy on blockchain. But those are just technical guidelines and policy papers. They are not binding liability laws. Even when individual states push blockchain adoption for e-governance, they're still fighting it out using the ancient General Contract Act. There's simply no bespoke liability law for these massive tech sectors yet, leaving a huge regulatory gap.
As we wrap up this explainer, I want to leave you with this final provocative thought. We are watching a legal landscape shifting at lightning speed, patching together aggressive IT rule amendments while still relying on aging fallback laws for modern tech. As these strict new SGI rules and 3-hour takedown mandates inevitably face rigorous court challenges, what does the future hold? Will this rapid, piecemeal approach successfully protect digital free speech and safety in India? Or will it ultimately collapse under judicial scrutiny and stifle the very innovation it seeks to govern? It is a critical question and one we all need to watch very closely.